everyone to our afternoon session of the Multi-State AI Policy Working Group. We are having an informational meeting on two proposed frameworks and trying to get presentation from various experts as to the positives for both and things that they would like to see changed, so that the goal is that we can work together to create interoperable legislation across the states. I would like to thank, I am one of the members of the steering committee, to thank all of the members of the steering committee, Senator Hester and Representative Elkins, who had run our meeting this morning, as well as Delegate Maldonado, Senator Rodriguez, Representative Capriglione, Senator Hughes from Alaska, Senator Gonzalez from New York, and Representative Bonner from Minnesota. So thank you to all of the members of the steering committee, as well as all of the members of our working group who are on, again, after the presentation. So the way we're going to go is after myself, it'll be John Verdi from the Future of Privacy Forum. And then from him, we will be recognizing different either members of industry or civil society to speak for 5 minutes to provide their viewpoint, and then for 10 minutes to take questions. So if anyone would like to ask a question, please go to the reaction, the raise your hand feature. And if we don't recognize you and you don't see a hand raised, please feel free to unmute yourself and ask your question. Before I turn it over to John, I just wanted to thank the Future of Privacy Forum for their role as a convener. And that's mainly their role is to help us to facilitate these meetings by providing the Zoom and some technical and administrative support. And that is really, they do provide information to a number of different sources and legislators around the country, but their role is to provide just information, and their role in this group is as a support to the legislators who are running this group. So with that, John, thank you for all of the support. You probably more than you guys realize you signed up for. So thank you to you, Tatiana, Fiona, Kier, and everyone at the Future of Privacy Forum. So John?
Thank you so much, Senator. Really appreciate it. Thank you to all the lawmakers and staff who are joining today. Thank you to all the commenters who made time to join us today. We appreciate all of your views and we appreciate all of your time. We are happy to lend the Zoom. We are happy to lend the live stream. And we are happy to do that because this group of lawmakers sets the agenda, picks the topics, drives the discussions. And if there's one thing we've learned at FPF over many years of working in the policy space, it's that smart policy is informed by a diverse set of points of view. And we think it's very important that when we are talking about a incredibly powerful technology like artificial intelligence. We are super optimistic about AI at the Future of Privacy Forum. We are optimistic about the opportunities for drug discovery. We're optimistic about the opportunities for AI to bolster human creativity and a whole lot more. We're also cognizant that lawmakers and others across the country have concerns about particular risks posed by the use of artificial intelligence in specific contexts. And we think that when lawmakers are contemplating legislation, it's important that they be informed about the technology, about the relevant business practices, about individuals' views on these matters. And we think it's super important that those views be informed by the perspectives of industry and civil society and academia. And we have a bunch of commenters here this afternoon. We had some other commenters this morning. And I know that there are many other folks who are publishing things online and reaching out to the lawmakers and trying to make their voice heard. And whether their voice is saying, please don't regulate AI in a particular way, or please do regulate AI in a particular way, please legislate here and don't legislate there, we think all those voices are valuable. So I thank you for the open-mindedness of the lawmakers who are joining us today, and I thank all the commenters for lending their expertise. And now I will go back to managing the Zoom.
Thanks, John. And as you mentioned, we're hopeful that this becomes a good opportunity for those who do want to share something to share with legislators across various states. And so our group Currently, there are 47 states represented, over 250 lawmakers represented as part of this group. So we're hoping that it's an efficient opportunity for you to get your information out there. And just to mention, we had a morning session today. We have this afternoon session. They are both being live streamed on YouTube and will be available afterwards from the Future of Privacy Forum YouTube channel. So with that, we will get to our presenters today. And our first presenter is Google, and I believe Alice Friend is presenting. And just a reminder, as Alice comes on, to legislators, if you have a question after Alice makes her presentation, please just raise your hand and then we will recognize you. So thank you.
Well, thank you, Senator Maroney. It's good to see you again. It's good to see Senator Rodriguez, I think, is on today. I'm very glad to be joining members of this working group. I've had the privilege of meeting many of you. I hope to meet many more. And I want to thank you for the opportunity to appear before you today to discuss the legislative frameworks you are considering. As the senator said, my name is Alice Friend, and I serve as the head of AI and emerging technology policy for Google's government affairs and public policy team. At Google, we believe that the first principle lawmakers should consider as they craft technology policies is ensuring all Americans can safely benefit from AI. AI is the biggest technological and scientific breakthrough of our lifetimes. And as you consider legislative frameworks in your states, we encourage you to preserve maximum flexibility to allow you to use AI so your people can do things like diagnose diseases sooner, deliver public services faster, empower scientists at your universities to make discoveries earlier, and to use finite resources more efficiently. And state and local governments really are benefiting from AI already. For example, we worked with the city of Memphis to train object detection models and use AI-enabled cameras to identify potholes and classify them for filling. The Wisconsin Department of Workforce Development used AI to improve its public benefits process, which led to a significant reduction in processing time while keeping fraud rates low. And the Central Texas Regional Mobility Authority is using AI to combat traffic congestion, improving overall management efficiency and the user experience. This focus on harnessing AI's benefits drives our own perspective on the best approaches to regulating the applications of this technology. We believe the context of use is most important in managing the risks of a general purpose technology like AI. Regulations should therefore focus on use cases. The good news is that much existing sectoral regulation already covers many of these use cases. We believe if something is regulated without or before AI, it is still regulated when AI is introduced. However, states may need to fill gaps in existing laws or issue clarifications of how existing law covers activities that incorporate AI, as some state governments have begun to do. We also need to avoid a patchwork of inconsistent laws that will slow innovation and result in uneven access to AI's benefits across the states. And this working group is a fantastic example of the effort to promote such alignment. As many of you know, regulatory fragmentation is a real and growing challenge for American businesses and for states that want to attract technology investments. The more we align regulations across states and with emerging best practices and technical standards like the ISO's 42001 standard, for example, the more likely it is that AI deployers can offer the same benefits to people in Missouri that they do to people in Massachusetts. We also have to ensure we balance regulation with innovation. Dictating the terms of technology development, for example, with requirements around model training, hampers the ability to experiment with better ways to develop AI capabilities. Many versions of this model bill currently include important exemptions for AI research and development, which we welcome. But we urge you to pause when thinking about regulating underlying technologies like general purpose AI models themselves. Safety mitigations can be targeted and more effective at the application and use case level, which users actually interact with, rather than dictating inputs engineers need to develop cutting-edge technologies. Regulation should also distinguish between the developers who make the AI systems and deployers who offer them to users for particular use cases. Different risks can be introduced at different stages of the AI value chain, from research to development to productization. And the actor that has control over a specific step in the AI lifecycle should be responsible for ensuring its safety. Consistent with these principles, we recommend that state lawmakers incorporate the following considerations as they draft legislative language. First, state laws should focus on high-risk AI, those systems that are intended to be used to make consequential decisions about consumers. But states should be careful of the unintended consequences of sweeping in general purpose AI or AI intended for other purposes, which could depress the deployment of AI in non-high-risk contexts. Second, regulation of high-risk use cases should focus on fully automated systems. Consumers are more likely to be harmed by uses of AI systems in the absence of human oversight or intervention, as recognized in the right to appeal, including human review. Use cases where AI input only assists human decisions or is only one factor to be considered shouldn't be subject to regulations. As you know, Google is both an AI developer and an AI deployer, and we develop many different AI models, which we implement for different purposes across our many products. We believe that laws should focus on developers' intended and contracted uses for the AI models and systems that they build. Deployers, for their part, should be responsible for following the developer's terms and conditions, choosing AI systems that are appropriate for their use cases, and identifying and mitigating safety risks that arise due to the context of use, including how the systems are implemented. Finally, the definition of consequential decisions should focus on clearly impactful decisions, such as the provision or denial of a service or a benefit. Vaguer terms like availability or opportunity sweep in many conditions that may not be controlled by the AI system in question. We suggest limiting the scope of what constitutes a consequential decision to ensure the regulations are focused on the highest risk outcomes. Google shares the goal of protecting users while leveraging this once-in-a-generation technology. Thank you for the opportunity to engage with you today and to be your partner in building a thoughtful and balanced AI governance framework.
Great. Thank you, Alice. Let me see if anyone has questions. I know I have some, but while I'm waiting, I don't see any hands raised. So before I go to my questions, I just wanted to thank Google. Connecticut, through Charter Oak State College, has partnered with Google to create the Connecticut Online AI Academy. Our goal was to train 1,000 people in our first year. And in the first week after our launch event, we had over 1,600 residents sign up for free training, and they will get the AI Essentials credential, an industry recognized credential. We are looking at expanding that as part of the proposed legislation this year, and hopefully working with even more corporate partners to get more training out in various areas. We're looking at adding in digital literacy, right, a stepped approach, digital literacy, AI practitioners, some more career certifications, as well as AI use for small business, AI for marketing, and other lessons. Okay, with that being said, I want to go back a little. So the consequential decisions, are you going to send us some written recommendations on the consequential decisions definition, as well as, I guess, some of the other definitions we're looking at, the substantial factor definition. So if you could send written recommendations, that would be appreciated. We can distribute them. I guess a question I have is, with a model, right, like Gemini, right? So you can go and others can integrate that into their product. So how do you suggest that we apportion risk when you have, really, it's a developer to a developer, right? They may be using that within another product. And how do we make sure when deployers have access to the information they would need to run the impact assessment, right? Like, so if a deployer was using that to make assist with a consequential decision.
Yeah, I mean, this is exactly the kind of thing we should be talking about, and goes with our recommendation to distinguish between the knowledge that developers have and the knowledge that deployers have. So the information that deployers tend to have are the conditions of use, the way they are offering an AI system, the way they are integrating it into an application or an overall process. And then they also have more knowledge about the users themselves as well. So they have a lot of tactile, sort of on the ground information about the way they're implementing the system. And the information that they need from the developer is about the system and its intended uses. There are always a terms of service and contractual language as well that also provides a lot of information. And we're very proud of ourselves for being leaders in the industry about providing information about AI models and systems so that downstream developers are able to build responsibly on those models that we develop.
And so that brings me to another question. In the bill, we say, providing the information through artifacts such as model cards or other impact assessments. Should we be saying system cards rather than model cards? Or would you just feel that since we're saying information such as the system cards are included, or should they be alluded to within the...
I would recommend pointing to model cards. I think that's the right level and type of information. It provides that high-level summary that we always emphasize, but again, in ways that are the most useful to downstream deployers. But I would also caution that what's helpful in the language is to focus on the outcomes you want to see. So it's really about asking developers to provide to deployers the information they need on safety, security, responsible deployment, and other such intended uses, and being prescriptive about that outcome that you want, but not as prescriptive about the types of information will also keep you flexible to technology as it advances.
So that was a question I asked in the earlier session of someone. So one of the items that are required, I mean, it just says other information required for the deployer to comply with their obligations under Section 5, I guess, or 4 is the deployers, right? So, I mean, is that what we should be saying for the developers then, that they're responsible for providing the information so that deployers can meet their obligation and just leave it that vague?
I think we should follow up with you more on what kind of specificity is the best balance between giving good guidance so that everyone knows how to comply, but again, also preserves that flexibility for technology to keep moving on, but for the legislation to continue to be valid and relevant. But, I do think that is the principle we want to preserve, is keeping in mind what are the existing regulations and the objectives that they have, and therefore what's the kind of information, kind of disclosures that will best support that objective. And I think we can work with you on that level of detail.
Okay, great. Another thing we're looking at including this year, which we didn't have in last year's legislation, was the integrator piece. And I don't know if you had any feedback, and there's in the Texas legislation, there's distributors, and the other legislation I think have integrators or distributors, right, are mentioned in the language, not necessarily interchangeable, but similar, right? I think. Do you have any comments on those sections of the bill pertaining? You have to wait.
No,
Yeah, it's going to happen to me too, that I'll have to wave my hands.
Just a little comedy we provide here. All right. Oh, come on. There we go. Apologies. So yeah, that's an important question. And, we always emphasize that there are clear distinctions between model developers, system developers, and deployers that we think can be delineated quite clearly in regulation. If we want to introduce other actors, I think, again, the principle to follow are those roles, is that information that they would have in their responsibilities and obligations, those additional actors would have, are they distinct from developer or deployer? That's the thing worth considering in proposals for additional actors to be specified in regulations.
Yeah, I wonder if sub-developer is a better, like, well, I guess we do lay out the developer to developer, right? Because sometimes developers are taking and they're intentionally and substantially modifying, which means then they become the developer, but there's still information they would need from the original developer. So that's, I think, an issue we need to figure is how do you apportion risk when there are multiple parties involved in an end product.
Yeah, and again, I think the information that you can reasonably expect an actor to have that is essential to being able to responsibly deploy the technology is sort of what should ground us here. And so again, I think for us, the cleanest way we have seen it is distinguishing between developers and deployers. But to your point, I think, you know, we can keep having a conversation about you know, how many distinctions and how many actors make sense in a regulatory framework. You know, generally reducing compliance burden sort of for everybody is a good approach, while adding clarification and specificity as well. So again, this is an area where balance is really essential.
Thank you. And then last question, I guess, is you alluded to ISO 42001. Now, I believe companies can get certified, right, that they're compliant. Is that how that works? I know, like, you know, I come from manufacturing. My grandparents had a manufacturing business, right? They would apply to be ISO certified. And you see that when I tour manufacturing plants, if they're ISO certified. Is that also a process with the 42001, which is their risk management framework, which is, you know, the NIST seems to be more recommendations, whereas this ISO seems to be more of like a checklist, of actionable checklist of things you need to do.
Yeah, we're early days, honestly, in establishing standards for artificial intelligence. The 42001 standard was the first one ISO came out with. They've actually introduced a few since that one. The sort of third-party certification ecosystem still isn't mature, in part because they're going to lag a little bit the standards as we develop them. But this is sort of an area that is healthy for us to develop and engage with. I know our cloud business, for example, has run checks against 42001 for compliance with it. So, you know, at the end of the day, not only do we have a safety and a responsibility interest, but this all comes back to business interest. So if we're able to demonstrate that we are following the standard that is accepted internationally, that's good. And it's also good for us to ground our regulation in those international standards, because again, then you have that interoperability of systems so everyone can benefit and everyone has the same level of safety.
Thank you so much, Alice. So I don't see any other questions, so thank you very much for taking the time to present to us.
All right.
Okay. Next, Meghan Pensyl from BSA. And again, just a reminder to legislators, if you have questions, if I don't see your hand raised and you have a question, please, you know, unmute yourself and ask your question.
Hi, good afternoon.
Hi, Meghan. Thank you for being here.
Thank you for having me. I'm just sorry about that. My Zoom was just lagging just a bit. But thank you so much for having me, Senator Maroney. Thank you to the Future of Privacy Forum for hosting today's event. As Senator Maroney mentioned, my name is Meghan Pensyl, and I am a policy director at the Business Software Alliance. BSA is the leading trade association for the global enterprise software industry. BSA members are at the forefront of developing business-to-business technologies, including AI, and their products are used by companies across every sector of the economy. Just as we saw states take the lead in adopting consumer privacy laws, states are again starting to lead with AI. Going into session, we particularly appreciate efforts like this one, which let you hear from stakeholders as you craft legislation, consider how it would work in practice, and help ensure you develop AI bills that achieve your goals. As you consider how to regulate AI, I want to underscore the importance of ensuring any AI legislation creates clear, thoughtful guardrails to protect consumers. To achieve this, we have 3 recommendations. First, AI legislation should focus on the uses of AI that have the most impact on consumers. When AI systems are used to decide whether consumers are granted or denied important benefits and services, companies should be accountable for developing and deploying those AI systems responsibly. The three draft bills we're discussing today already recognize the importance of focusing on high-risk AI, but need more work to achieve these goals. We recommend that high-risk AI system be defined as an AI system that is specifically designed or intentionally and substantially modified with the intended purpose of making a consequential decision about a consumer. We also recommend that consequential decision be defined as a decision made by a deployer that has a material, legal, or similarly significant effect on a consumer's eligibility for and results in the provision or denial of housing, employment, credit, education, access to physical places of public accommodation, healthcare, and insurance. We also have a recommended definition for intentionally and substantially modify and quite a few other terms that are relevant to this type of legislation. And I'd be happy to provide those to legislators after today's event. In these high-risk scenarios, new safeguards are important, and legislation can leverage tools that already exist to help companies identify and mitigate potential risks. BSA supports requiring companies to adopt risk management programs and to conduct impact assessments if they develop or deploy AI for high-risk uses. This can help companies identify and mitigate risks when AI makes important decisions about consumers and increase trust that AI is developed and used responsibly. Second, AI legislation should reflect the different roles and responsibilities of different actors along the AI value chain. The AI supply chain is evolving, and AI legislation should not create one-size-fits-all requirements when companies have different roles. The three bills we're talking about today recognize that there are different types of companies, but we think all three draft bills need more work to help ensure that legislation functions in practice. We recommend defining a developer of a high-risk AI system as an entity doing business in the state that makes an AI system publicly available for use in the state, and that also does one of the three following things. First, designs an AI system specifically intended to be a high-risk AI system. Second, intentionally and substantially modifies a high-risk AI system. Or third, intentionally and substantially modifies a non-high-risk AI system so that it becomes a high-risk AI system. We also recommend defining deployer as an entity doing business in the state that uses a high-risk AI system to make a consequential decision. It is essential to get this right. How the obligations in your bills will work in practice depend on correctly defining roles and responsibilities of different entities along the AI value chain. Third, AI legislation should promote interoperability and incorporate stakeholder feedback. Every state is home to global companies, and your legislation will be most effective when it is interoperable with other approaches. We appreciate the work of this group to gather and share information among legislators in different states. We also encourage you to continue working with stakeholders as you develop your legislation to understand how your AI bill will work in practice across a range of different industries and uses. Thank you very much for the opportunity to present, and I look forward to your questions.
Great, Megan. Thank you so much for your presentation. Let me just look. Oop. I turned the camera off because I was getting something to eat. I didn't want people watching me eating, so I forgot
No worries.
about that. Let me see. I don't see any hands raised, so I'm going to start. One, thank you for giving specific recommendations. I appreciate that. Please, if you could send that along in writing, and then we'll make sure that that gets distributed to all of the members on the email list for the group. I just want to go back because when you said the definition for consequential decision, you know, it sounded like, oh, okay, now that I'm saying it back in my head, I think you're covering one of my concerns, but when you say credit services, right? So do you mean lending, financial lending? Because that's an area where we know there are examples of algorithmic discrimination, right? And we've seen noted examples versus just like a credit report like, wait, I'm not sure. I just want to make sure your intention would be to draw in the actual lending. And
Yes.
I get it that there are concerns, like when it was just said as financial services, that there were people with like rewards points. They were afraid that it was drawn in and all of these different things that they thought were drawn in that were not the intention. But I'm still trying to figure out what's the best wording to make it clear we mean lending, right? So I mean, what are your thoughts on using just financial lending services rather than credit services, or financial lending services and credit services?
Yeah, thank you very much for the question. I think when we say credit, we absolutely mean to include lending, and we think of it as like the extension of credit, which I think means lending in a lot of circumstances. And so, if you say credit or lending, I think both of those approaches would be workable. And I will say for all of our recommendations, we present all of these recommendations with a lot of humility. And so, if you think there's a better way to get at any of the concepts we're presenting, we're absolutely happy to work with you on that.
Right, thank you. Now, your definition of developer, right? So develop a high risk, intentionally and substantially modify a high risk, or intentionally and substantially modify, I can't remember what you said, but basically a general purpose to make it a high risk. Now, I guess the concern is, right, like, and why I'm considering including general purpose is that if you are going to intentionally and substantially modify a general purpose to make it a high risk, how are you going to run those impact assessments unless they're required to give you a certain amount of information? And what would that information and that requirement be?
Yeah, I think it's a fair question, and I appreciate you asking it. I think the way we think about it is general purpose AI models are very different from high risk AI systems. And we generally tend to think that there would have to be a lot of modification that goes into creating a high risk system, because general purpose AI models might be developed for thousands of different purposes or no purpose at all. And so we have tried to write a definition that holds companies responsible when they are taking something that is general purpose and they're making it high risk. And we have thought about obligations in this scenario as making sure that that company is responsible for the information that they have access to and the risk that they introduce. I think it's a fair point that should they have access to information from another company, but then I tend to agree with you. Then I think having a mechanism for information sharing is going to be critical for that company that is creating that high risk AI system to be able to comply with the legislation.
Right. And so, I mean, now I'm just kind of thinking out loud, which is always dangerous. So, and I'm wondering if then there is like an either or, right? Like either you can create tools so that it's sub-developers or the integrators who are using your general purpose can run the impact assessments, or you can give them the information necessary, right? I don't know if that's one way to approach it. It's something I think that we'll need to workshop. On to another thing we're trying to workshop. Integrators. I know your members are
Yes.
very mixed on this, so I'm not going to ask you to give me an opinion. But well, I will ask you, like, where would you say we look to try to get that section right? Or is it do we look at more of a sub-developer rather than an integrator? Or
Yeah,
is there any consensus forming among your members of which way to go?
Yeah, I think you are absolutely right that we as an organization are agnostic as to whether or not legislators include this third role. And that is because we have different members with different views on that topic. But I think something that all our members can agree on is that whether you include two roles or you include three, they have to be distinctly defined. And I think some of the concern I heard and what I saw in the Texas draft is that there isn't a distinct role for distributors that is distinctly defined from developers and deployers. And we're concerned that's going to create a lot of confusion when those companies go to comply with this type of legislation. And so I think to the extent integrator is included, it has to be separately defined. I think the Connecticut and the multi-stakeholder drafts say an integrator is not a developer. I think you could make that definition stronger by saying integrators also aren't deployers. And so I think we have a few ideas on this topic. And to the extent folks do want to include that third category, we're absolutely happy to be helpful.
Yeah, I'm not crazy about the definition, so any help would be
Yeah.
appreciated. That's the purpose of getting multi-stakeholder feedback is to improve those definitions, and so to put them out there and to see what information we can gather. Are there any other questions? Senator Rodriguez, do you have a question for Meghan?
Just for forgiveness for being here late. That's really all.
Thanks for joining us. So let me look and see. I don't see any other hands raised. Just wondering, let me see, just so your 3 recommendations, consequential, and are you going to send us written suggestions on the substantial factor definition as well? Or did you
Yes.
have recommendations on that? I don't see in my notes.
Yeah, I think we have spent a lot of time talking with our members on substantial factor. I think there is some support among our membership for focusing on terms like principal basis or controlling factor, but I'm happy to follow up with the group and provide some written thoughts on that.
Okay, great. Thank you very much. Oh, Senator Rodriguez.
Yeah, and I just wanted to clarify. I think I shared with a couple of you that somebody was referring me to Virginia's substantial factor definition, which people are looking at, which I'm not sure we're there yet, but I just heard that today. And then for this group, I wanted to put out, I don't know where we've talked about some discussions being had with how we look at some reprieve for small business here on the AI task force. They're going to start putting stuff to align with our privacy laws, which I was like way more complicated. And if we look at anything to help the small business startups, how do we define what that is? Part of me started thinking about how many users it interacts with versus the size of the company might be a route to go, because you can have somebody making millions of dollars with 2 people or somebody making millions of dollars with 50 employees. So that's the hard part in this industry, to figure out what's startup small business. And I don't know if BSA has some thoughts, but would love to hear if you could help with that.
Yeah, I'm not sure that has been a particular focus among our membership, given that we tend to, not represent the smaller businesses, but our companies serve a lot of small businesses. And so I will take that back to them and definitely follow up.
Yeah, because a lot of them do provide services to these groups too. So
Absolutely.
And the other, Meghan, if you could, I think one of the ways I think to provide some relief or to developers or to continue incentivizing innovation is the sandbox, which I know Utah is operating, but I would like to see if there are other states or if there's ways states could work across, recognizing sandboxes from other states. So I'd love some feedback on that.
Yeah, happy to take that back as well. Thank you.
Great. Thank you. Okay. Next up is the CDT, the Center for Democracy and Technology, and Matt Scherer. So while they're letting Matt in, just a reminder for legislators, members of the group, if you have questions, please feel free to raise your hand or unmute yourself. We will be sending out as we collect the written suggestions from our presenters. We will send that to everyone. So Matt, it looks like you're in, so why don't you take over?
Thank you. Thank you, Senator. I'm going to try to share my screen. I think that I have the right to do that. So give me just a moment here. Senator, can you see my screen, the outline page?
Yes, I can.
Okay, thank you. All right, well, I'm just going to give a quick outline of what I'm going to cover. I'm going to start with a framing example around Cigna's use of a hidden algorithm to mass reject medical claims. I'm going to transition then into why strong transparency provisions are essential in any AI law. And then I'm going to go over how substantial factor requirements, and unfortunately, particularly the substantial factor requirements that are in the Connecticut and Texas bills that we're discussing today, and weak enforcement can undermine transparency. And that's true both for AI laws and, in fact, for existing consumer laws. And the better approach, I would argue, is Assemblymember Bauer Kahan of California's AB 2885 definition of automated decision system. And really, when you hear somebody say that the law should only apply to AI systems that are intended to be used for particular decisions, or that play a dominant role in decision-making processes, or that there should be an exemption if there's a human in the loop, what they're really asking for, whether they intend to or not, is a loophole that would give companies the unilateral right to evade the law. And with that, I'm going to transition into my framing example, which is comes from a trio of articles that the nonprofit investigative outlet ProPublica did on the healthcare giant Cigna, which secretly used an algorithm to mass reject policyholders' claims that were supposed to be reviewed by doctors, and that they told the outside world were being reviewed by doctors. But in reality, they were pressuring those doctors to simply rubber stamp algorithmic denials. One former physician said, "We literally just click and submit." And then they actually threatened to fire a doctor who pushed back against this practice. And the key takeaway is that Cigna told the outside world that human medical directors were reviewing all of these claims. But in reality, they pressured those medical directors to accept algorithmic quote unquote recommendations without reading them. And unfortunately, the consumers, the healthcare policyholders who had their claims improperly denied, they got no recompense for this. This was perfectly legal under current law, and the consumers were left holding the bag. Now, I want to shift gears and talk about why transparency in AI-driven decisions is so important. And the first reason is that consumers and workers simply deserve it. When somebody is going to be subjected to an AI system that could impact key decisions about their lives or livelihoods, such as whether they get a job loan or medical coverage, they should know about it. And if they're rejected because of an ADS decision or recommendation, they deserve to know why. And in fact, when the first wave of automated decisions started to hit the market in the 1960s with credit reporting, we passed the Fair Credit Reporting Act, or Congress did, I should say. Unfortunately, Congress is gridlocked now, and I would argue that this is the perfect time for the laboratories of democracy in the states to try different approaches here, which fortunately, obviously, the policymakers on this call are doing. But a world where people's lives are determined by hidden algorithms is dystopian. Now, the second reason is that transparency is essential for enforcement of any AI law. Impact assessment requirements and prohibitions on harmful uses are going to be impossible to enforce if companies can keep their use of an ADS hidden. And in fact, that same lack of transparency means that existing consumer protection, labor, and civil rights laws can't be enforced effectively with respect to automated decision systems. And lastly, information asymmetry simply makes the market for these tools inefficient. It allows AI snake oil and harmful AI systems to proliferate. Now, how can substantial factor requirements, at least if they're not framed properly, undermine transparency? First, bear in mind, again, consumers and workers often don't know which companies are using ADSs, much less how they're using them. And companies have strong incentives to maintain that information monopoly. AI-driven decisions are deeply unpopular with consumers and workers. Polling by Pew and Consumer Reports bears this out. It also, maintaining their information monopoly, avoids regulatory scrutiny under existing consumer protection and civil rights laws. And if the tool's ineffective, the lack of transparency means that they can keep the outside world from finding out. As a result, companies will exploit narrow definitions or other loopholes in ADS laws, such as the sorts of exemptions that I mentioned before, that apply if there's a human who theoretically has final say over algorithmic recommendations. Again, remember the Cigna example, where in theory there was a human who had final say, but in reality the company was pressuring them to be rubber stamps. So there's a catch-22 that gets created if you have those types of loopholes in a definition. If a company can justify to itself that its use of an ADS is not a substantial factor and is exempt from disclosure, consumers, outside experts, and regulators will have no way to learn about the AI system and challenge the company's decision not to disclose. And in other words, poorly phrased substantial factor requirements give companies the ability to unilaterally opt themselves out of the law with no outside visibility or accountability. And unfortunately, the definitions have covered ADSs in both the Connecticut bill and the Texas bill and the Virginia bill, which unsurprisingly, a number of industry groups I know are trying to tout as a model, contain those types of definitional loopholes. It appears that the definition in HB 1709 in Texas uses a definition that's drawn from the regulations on NYC's AI and hiring ordinance. And as a result, though, it would likely suffer the same fate as that ordinance. There was an article by Consumer Reports and Cornell researchers that showed basically companies have ignored that law, likely by exploiting those definitional loopholes and relying also on the lack of strong enforcement. SB 2 also has a substantial factor requirement that only applies when an ADS actually alters a decision that would allow companies to avoid disclosure requirements. That's a problem because how can an outsider ever prove that a company would have reached a different decision absent the ADS, especially if they don't even know that the ADS exists? And finally, SB 2 also has a loophole that says if a human has theoretical authority to override the ADS, and that, again, that suffers from the same human in the loop exemption, if you remember the Cigna example. So both bills also, I want to note, contain trade secret exemptions that would allow companies to unilaterally opt out of disclosure simply by designating info about their ADSs as a trade secret. That is a similar loophole. Unscrupulous companies often claim trade secret protection to avoid accountability. Maybe the most famous recent example is Theranos, whose blood testing technology didn't work, but they kept the public from finding that out by claiming that information about it was a trade secret. And also, I would argue that trade secret exemptions aren't even necessary in these bills because they don't require companies to disclose anything other than what vendors routinely share with potential clients and usually post on their websites. So the better path forward, I would argue, is to have ironclad definitions that require companies to disclose any use of ADS that assists, influences, or otherwise impact consequential decision-making processes. And again, the model I would argue for is Rebecca Bauer-Cahan's law that was enacted last year in California, which would apply to any computational process derived from machine learning, statistical modeling, data science, or AI that is used to assist or replace discretionary decision-making. And with that, I will open myself to questions.
Great, Matt, thank you very much. And let me see if anyone else has a question. I will ask my question while I'm looking to see if anyone else, okay, I don't see anyone right now. How would you recommend we bifurcate responsibilities, right? Meaning, would we go to a controlling factor or a contributing factor? I think the original version of the Texas Responsible AI Act used contributing factor. So would we say if the high-risk AI system is a contributing factor to decision, you'd have to notify consumers, and then the other requirements would only come in if it were a substantial factor? Or have you given any thought to how that might work?
I have, and with the caveat that I know a lot of other civil society groups have different views on this point.
Right.
But my take is that transparency requirements, all disclosure requirements, all explanation requirements that are consumer facing, and also any requirements that mean that developers have to provide information to deployers to fulfill their obligations under the law. Those are subjected to a contributing factor type standard like AB 2885 or the original Texas definition. For other requirements that actually require impact assessments, that require additional procedural steps beyond simply providing information to consumers or downstream deployers, those sorts of requirements could be subjected, I would say, to a higher standard, such as I would say that the substantial factor requirements that are currently in the law would be appropriate for that. Controlling factor, I'm still very skeptical, because it's so easy to just assign a human rubber stamp and say they're not the controlling factor. But I think a higher threshold could be appropriate for, again, impact assessment, risk management program, right to appeal, right to opt out if it's in there, and hard prohibitions also, it would be appropriate maybe to have that sort of higher standard for.
Okay. So you would apply I guess the higher standard to the right to appeal as well.
Right to appeal, although right to correct, which again, to use the example of FICRA, like
Right.
if the explanation shows that, for example, it was clearly based on erroneous data, that they had confused somebody's information with somebody else's, then similar to under the Fair Credit Reporting Act, they should have the right to make sure that that information is corrected.
Yeah, and Steve Elkins did a good job of including that in the Minnesota data privacy law where, right, you have the right to see the data your decision was based on. He based it off of FICRA, and that your appeal is only if your original decision was based on wrong information. So you can correct it and then and then appeal, which is what I was looking to model. So I'm going to throw this out. You don't have to answer because I didn't prepare you on it. It's just something I've been thinking about. I think my understanding is in the draft California regulations, they give a choice of the right to opt out or the right to appeal. What are your thoughts on that?
I think that it depends on the setting in which the decision is being made. Opt out might make more sense for decisions that are especially that are relatively low frequency and high impact, such as whether or not somebody will be terminated or hired for a job. But I think that the right to appeal makes more sense for things like, banking and credit decisions, healthcare denials, and other things where, those types of decisions are made so frequently with respect to many different consumers that, imposing a before the fact opt-out requirement would impose like a particularly high burden. But again, I think that this illustrates why, for those sorts of requirements, a higher threshold of what type of role the AI plays in the decision-making process might make sense. At least, though, if there's a contributing factor standard for the disclosure requirements, the consumers have the ability to kind of see for themselves whether or not the information that the decision was based on was accurate and appropriate.
All right, I'm going to throw another thing at you that I haven't prepped you for. So, one of the things I like Representative Capriglione did in the Texas bill requiring, certain information to be placed on the AG's website, right? Like how you could report a problem and access your rights. What would your thoughts be of expanding that to, giving information on how to for your existing rights in regards to discrimination? So in Connecticut would be how to file a complaint with CHRO or others. And then the other is, what would models be of, I think when, I'm trying to think of which of the states, some of the states have done this, was educational campaigns, right? Once you pass the bill, because, what good is a bill if no one knows it exists, right? And for businesses as well as for consumers. So what would your thoughts be in terms of how to reach out to businesses to let them know of their new obligations and consumers to let them know of their new rights?
As a former corporate lawyer, I can tell you that there's going to be little risk that most companies won't be aware of these requirements relatively quickly. I used to work both for a boutique employment law firm that serviced mainly relatively small clients, as well as a big one. And any law firm worth 10 cents, is keeping a very close eye on any sort of new law that would impact their decision-making processes in, whether it's for employment or business operations, et cetera. So, for consumers, I think the more information gets out to consumers and workers, the better. And for the same reason, the suggestion of posting information on the AG's website, I think that that's always a great idea. I think that in general, I have some level of faith that as long as, again, there are disclosure requirements that require the information to be provided directly to the consumer or the worker who is affected by it. To a certain degree, that undercuts, that means that there's less of a need for a, formal advocacy or informational campaign to make sure consumers are aware of it. So, again, though, that underscores the need to make sure that consumers are under the law getting that necessary information about the systems.
Thank you. So now I'm going to go to Texas Responsible AI Act. Some of the things that okay, never mind. I thought someone else had a question, but a couple things, again, very interesting that I like, thoughtful, that Representative Capriglione is doing in the bill are modifying their existing data privacy and looking at, giving you the right to know if your data is being used for training AI systems, the right to opt out of the sale for AI systems, but then also requiring updates to privacy policies to let you know. And again, you don't have to answer because I'm surprising you with these, but I would be interested if you have thoughts on those policy changes.
Well, once upon a time, I did improv, so I'm used to thinking on my feet. So
So
feel
you're
free
more
to hit me
trained than
with
I
those.
am.
But I think that, well, first off, I do want to say none of this is obviously meant as a criticism of you, Representative Capriglione. Like, these are difficult issues because the technology has already accelerated far past existing laws, and we're now trying to play catch up, everybody in the policy world. So, that's exactly why this is a great opportunity for the laboratories of democracy to be at work, have slightly different approaches in different states to these issues so that we see what works, what doesn't, whether certain loopholes kill the ability of a law to be effective, or whether they don't have the impact that advocates are worried about. With respect to, like particular information, sorry, the question about Representative Capriglione's bill was, I lost my train of thought in my
Yeah.
in my response there. My improv skills have clearly faded over time.
You're good. You knew I'm a legislator. You were like made me look at the squirrel running over there, and I forgot what I asked. No, right to opt out, right to know if your data is being used for training, right to opt out of sale for training, and then updating privacy policies to let people know if their data is going to be used.
Yeah, I think that all of that makes sense. And again, like it also points to it's difficult to do AI if you haven't even started the process of regulating privacy. Because if you haven't even started that process, consumers don't have kind of any existing rights to review or access or even know about how their data is being used by these companies. So I think that those types of requirements are especially essential if a state doesn't already have a privacy law that provides consumers with some right to access that information. I do think that it's important. Like, one thing to bear in mind is that a lot of the times consumers aren't going to necessarily be able to act on that information themselves. They might, but they will have the ability to call the attorney general in their state, or they will have the ability to share it with an attorney who can maybe tell whether their rights are violated, or with an advocacy organization, or if they're a worker with their labor union, if they're represented. So the more information you make available to consumers, the better able they'll be to vindicate their rights, not only under that law, but kind of as those examples indicate, under other existing consumer protection and privacy laws as well.
Great. Matt, thank you so much. If you could send along your PowerPoint and any other written recommendations, we would really appreciate that. And
Happy
then
to. Yeah.
yeah. Next, we're on
Thank
to
you. Thank you.
Ryan Harkins from Microsoft. Hey, Ryan, the floor is yours.
Good afternoon, Senator and members of the task force. I'm Ryan Harkins with Microsoft, and thank you for the opportunity to be with you today. I'd start by applauding the work that you and other members of the task force or the working group have done to create this framework. We think it's sensible, it's thoughtful, and it's innovative, and there's a lot to like about it. And as you know, Senator, we supported your bill, Connecticut SB 2, last year. We were supportive of the Colorado AI Act, and I'd certainly applaud Senator Rodriguez for getting that over the finish line. And we'd like to be constructive partners and supportive of everyone on this group as you attempt to move legislation in your respective states. We like, number one, that it takes a risk-based approach by focusing on high-risk AI systems, those that are used to make or be a substantial factor in making consequential decisions about people's lives. I also think that the framework attempts to grapple with a problem that has long been present when it comes to regulating technology, and that is, how do you ensure that the laws you pass keep up with the pace of technology and aren't out of date as soon as the law is passed? And this framework takes an innovative approach by utilizing concepts that perhaps ironically have been around in the law for hundreds of years. And that is tort-based standards of care. And so while we are at a place and at a time where the technology continues to evolve rapidly, state-of-the-art best practices on what needs to be done in order to ensure that the technology does not pose harms, will not discriminate, are continuing to evolve and likely will continue to evolve. And so by utilizing a standard of care, you allow the law to evolve as the technology does as well. We also think that it is smart and innovative while you are imposing a standard of care to provide some guidance or certainty about what is required today in order to meet the standard of care, and the utilization of a rebuttable presumption, providing, in essence, that if you comply with the governance and transparency obligations in the bill, that you, by default, have met the standard of care, is a good approach. And we also like the utilization in states where it's possible to provide rulemaking authority to some kind of standards body or entity, as in Colorado with the Attorney General's office. These are big and meaty and complex issues, and it's hard to get everything right in the statute. And providing for rulemaking authority, in our view, affords the flexibility that is necessary to ensure that once the law is passed, it can and will be implemented in ways that make sense. There are, some suggestions we would have to address some specific challenges that some of the bills pose. And in the interest of time, I would highlight just a couple of those. One is that we've seen legislation, as we saw in the Colorado AI Act, proactive notification obligations imposed on developers of high-risk AI systems to provide notice to, say, the Attorney General and perhaps to other parties under certain circumstances. Say, if you have discovered it is likely or reasonably likely that your system has caused algorithmic discrimination. And in our view, tying notification obligations like that to what can oftentimes be a complex legal conclusion, whether existing anti-discrimination laws have been violated or not, is for many reasons unhelpful and can be problematic, because it can be hard to determine whether a system has in fact caused, let alone is likely to have caused, algorithmic discrimination. This is a very different scenario in our view, empirically, than, say, data breaches, where it is easier to determine whether a data breach has occurred or not, and therefore it's easier to determine whether a notification obligation has been triggered. And one of our concerns is that by tying a notification obligation to a complex legal conclusion, you may inevitably lead to over notifications where companies are notifying the Attorney General's office to comply with the notification obligation, irrespective of whether there's been any underlying violation of the law. The second thing I would note is that the TREGA, the Texas bill that Representative Capriglione has put together, and we applaud Representative Capriglione for all of the work he's done to date. It contains two different sections addressing the capture of biometrics identifiers, as well as categorizing individuals based upon or inferring sensitive attributes based upon the processing of biometrics. And we would suggest that Texas already has strong prohibitions on the collection and misuse of biometric identifiers, both in its biometric statute, but also in the Texas Data Privacy and Security Act. And we would just suggest that those provisions are perhaps unnecessary, given the protections that already exist in Texas law. And they may also be overbroad because they would apply to systems that have the quote unquote capability of capturing biometrics or of inferring certain things, which could capture just about any system which utilizes biometrics. And then finally, we would note that the provision in TREGA, which would impose requirements on platforms to police advertisers, from deploying systems that could expose users to algorithmic discrimination. That was in the previous version of TREGA. I know the current version has updated that to require platforms to require advertisers to agree to certain terms and conditions in this regard. We think that the original provision would have been extremely challenging to comply with for platforms. And we're not sure that the subsequent provision, practically speaking, will accomplish a whole lot. We would wholeheartedly agree that the requirements that apply to developers or deployers should apply to advertisers as such, and would suggest that perhaps that would be sufficient. But again, I applaud you, Senator, and others on the call for all of your work on this framework to date. We look forward to continuing to work with all of you, and I'd be happy to try to answer any questions.
Great. Thanks, Ryan. So one of the things I had tried to, or one of the provisions we put to test out again, to kind of workshop, was putting a threshold for the notification. So instead of at one instance, right, to set a threshold similar to how it is in the data breach laws, right, that there's a threshold before you have to notify. So I think we had set the threshold at 1,000 instances before there would be that requirement to notify the AG. And I was just wondering your thoughts on that approach versus, obviously, I would assume your preference would be to not have it at all. But what about that approach of setting a threshold at 1,000, or I don't know if that's the right threshold, 500 instances, 1,000 before you have to notify?
Well, I mean, it certainly helps some, but it still, in my view, doesn't resolve the fundamental challenge, and that is determining whether, what can be a complex legal conclusion, whether that in fact has occurred. And I completely appreciate, I think, what the motivation is behind the provision. If a company has been using a widget that is in fact discriminating against people on a broad scale, you want to know. And so we certainly are open to conversations about how to crack this nut in a way that doesn't pose the challenges that we've identified. If I had a solution or a silver bullet, I'd offer it today. Unfortunately, I don't, but I'm hopeful that people who are much smarter than I am can perhaps, figure something out.
As am I. I'm hopeful people much smarter than I am will figure this out and send it to us. But maybe if we give you a night to think on it, you could come back with something. Again, one of the main reasons of working together across states is to look for consistency in definitions. So I don't know if there are any any suggestions you have in regards to the definitions, the consequential decision or the substantial factor definitions, or any input specifically, as well as again, trying to get input, and it doesn't have to be today. You could send hopefully written suggestions on the integrator section, which is new from last year.
Yeah, we certainly have suggestions on how to tweak definitions. I know that, we've provided some previously, and we'll provide some more in writing, Senator. As to the inclusion of a new term, integrator or distributor, I would say at a high level, we certainly are supportive of the deployer-developer distinction and framework. We think it makes sense to ensure that everyone in the ecosystem is responsible for what they should be responsible for, and that their responsibility and obligations are premised upon the knowledge that they should be deemed to have, given where they sit in the ecosystem, and the ability they have to make changes and mitigations in order to prevent discrimination. We have not been convinced to date that it is necessary to introduce a third term beyond developer and deployer. But we're certainly open to being convinced otherwise and to engaging in those conversations. But as we sit, I'm not sure that it's necessary. And, in general, I think anytime you introduce complexity into a legislative framework that isn't necessary, you introduce opportunity for mischief. At a high level, I think simplicity is better. And so I'm just not sure, as I stand here today, that a new term is in fact needed.
Great. Thanks, Ryan. So the old KISS principle, keep it simple, stupid, right? So
Something like that.
So great. Thank you very much. If you could send along any, if you have a written copy of your remarks, as well as recommendations, specific recommendations on definitions, then we'll make sure those are distributed to the whole group. So thank you. And I think with that, Senator Rodriguez, are you going to take over moderating?
I will.
Thank you.
Jumping around. I see the next person on the list is Amazon, which who do we have up for that?
I believe Nicole from Amazon.
I only have Amazon, so I don't have.
Yeah, we don't
Nicole?
have to. Nicole, yeah.
Hi, Nicole. Can you hear us?
Hi there. Yes, I can hear you. Hopefully you
All right.
can hear me.
You're up.
Thank you so much for having me. So thank you, Senator Maroney, and thank you, Senator Rodriguez, and members of this multi-state working group for the opportunity to discuss the high-risk AI framework and the Texas Responsible AI Governance Act. My name is Nicole Foster, and I lead Amazon Web Services global policy efforts around AI. And I really appreciate this opportunity to speak with you today, and I commend the multi-state working group for its dedicated work on this complex issue and your efforts to foster interstate interoperability for AI legislation. Across Amazon, we've been developing and deploying state-of-the-art AI and machine learning models to power customer experiences for over 25 years. We use AI in both the customer-facing services and our internal operations. And our perspective is informed by our unique position as a developer of AI technologies, as well as a deployer of AI tools and services. We're committed to both responsible development and deployment of AI across all of our businesses and to furthering its science. We have published or funded over 500 research papers, studies, and scientific blogs on this topic. And with more than 100,000 customers using AWS AI/ML services offered in the cloud, we are helping our customers transform responsible AI from principles into practice. And to date, we've developed over 70 internal and external offerings, tools, and mechanisms that support responsible AI deployment. We've also created AI service cards where AWS customers and deployers can find information on the intended use cases and limitations, responsible AI design choices, and deployment performance optimization best practices for our AI services. And so while AI is already subject to a broad range of laws and regulations protecting against many risks associated with the use of AI, Amazon is supportive of targeted and reasonable regulation to ensure that organizations adopt governance-based safeguards where AI is being used in high-risk ways. To that end, we will only be able to unlock AI's full potential by fostering greater confidence among consumers and businesses. So that means addressing potential risks and harms arising from the adoption of AI technologies and earning and maintaining public trust in AI systems. So with respect to regulation, it's important to strike the right balance between innovation and risk mitigation, which can particularly affect startups and small businesses. And as many of you know, it can be humbling to reconcile how policy and this new technology can work together. And I commend this group for their work. Overall, we welcome the framework of the multi-state legislation or high-risk AI approach shared for this meeting. The draft multi-state framework you've shared sets reasonable risk management requirements for developers and deployers of high-risk systems, recognizing the role each player performs in the AI value chain. We also applaud the specific reference to leverage AI standards. While the foundation is strong, there are areas that would benefit from some further clarification. For example, we recommend refining definitions of key terms such as consequential decision and substantial factor. As currently written, these may be overly broad, potentially capturing decisions where automated systems and AI play a role but weren't decisive factors. Clarifying these definitions would provide greater compliance certainty and maintain the legislative text's intended focus on truly high-risk use cases. We applaud and appreciate the progress already made in this direction, particularly the updates throughout the legislative text that clarify requirements to reflect known and material impacts rather than reasonably foreseeable ones. We aim to be a constructive partner as you navigate these complex and rapidly evolving technologies. Your willingness to engage in these working group discussions is invaluable, and we remain committed to continuing collaboration with legislators, technology companies, and organizations, and the AI community to advance the responsible and secure use of AI. Thank you for your consideration, and I welcome any questions you have.
Thank you, Nicole. Colleagues, is there any questions? Senator Maroney, as part of the group now, you can have some questions.
Shocker, I have a question. Thank you very much, Nicole. Two questions. One, will you send us specific recommendations on the consequential decision? And I think getting that definition right is essential, because I think a lot of the pushback we hear are on things that were never intended to be, and in our minds aren't drawn into the bill. But if we can provide clarity, I think that's always a better thing. So if you could send along specific recommendations, or and then we'll send them out to the group. The other thing is, I think you mentioned, referencing existing standards. So we referenced NIST, we referenced the ISO 42001. I believe now, did Amazon get certified with the 42001? And can you talk about that process? Because I think one of the things we'll hear pushback regarding the rebuttable presumption, right? Like the AG's offices may say, well, it makes it harder for us to enforce. There's already a high bar that we've heard, again, from some of the groups early who presented this morning. They didn't like the rebuttable presumption. So I don't know, because they said, well, you're just self-certifying that you comply. But ISO is a way to have your risk management framework evaluated. And could you talk about that?
Yeah, I thank you for the question. So we very much view it as a business decision to certify against these standards. And clearly this group is motivated by the notion of trying to create interoperable regulatory frameworks. And standards are a great way and mechanism to do that, because if you reference the standards and you can certify against the standards, then it's a way of kind of for companies to be able to scale. And so, and the other thing is if you think about how we think about this in a customer environment as well. So, for example, if you think about, so our approach to this, I'll just explain, has been we've had 4 of our sort of most advanced AI services evaluated and certified against the standard by a third party to do that. And so very much looking ahead to where regulation is going and thinking about how do we put the right things in place as quickly as possible to, I think, assure customers that we are, we've taken the right steps, and actually to document those steps so that then customers can take that documentation as they think about their own responsible AI deployments. So that's part of it. And then if you think about too, we're a one-to-many company. And so the ability to kind of validate or prove that to many customers is obviously really valuable to us in that process. And then also from a compliance perspective, I mean, we work with a lot of regulated industries, and a lot of those customers, for example, even today, before existing before any AI legislation has been passed, will have regulatory requirements. And so we often, instead of having each individual customer audit our systems, we can do one audit that is then provided to all of those customers. So there's a whole bunch of business reasons why this can make a ton of sense. And even small companies, I think, would see a benefit from thinking about how they can leverage standards like ISO 42001, because in the same way, it gives them a validation to their customers that they have thought through the right sort of steps to evaluate risk and mitigate risk and put the right safeguards in place. And we are hoping that this is something that actually the market demands, not just legislation, that our customers are asking us about ISO 42001, and that sort of also promotes the reference of these standards and the leveraging of these standards.
Great. Thank you, Nicole. So I guess just one other question, actually one other question and then a request for some written follow-up. So question, I believe you're from Canada, correct?
I am.
And so I know at one point that they had proposed regulations. They were supposed to have been drafted by last year. Where are they in the process of their regulations on automated decision-making?
I mean, I could talk about the politics in Canada at the moment all day. So as you may know, the Prime Minister resigned and prorogued the House of Commons. Prorogation suspends all pending legislation. So that bill essentially died on the order paper before it could pass prior to prorogation. And there's a lot of anticipation about a potential election and maybe a change in government. So I would say that it's a pretty uncertain future for AI legislation or regulation in Canada at the moment.
Okay, great. Thank you. And I guess the last is just, on the integrator distributor piece, if you could send some, because I think the way I read it, you would be a distributor, right? Because you allow on Amazon Web Services people to select between models they use, but then also I think that's something, if you could send some feedback to help us get that piece right, that would be appreciated.
Yeah, I mean, I think just to give you a high level comment, hopefully I'm not running over time, but I think our kind of view would be I was listening to colleagues from Google and Microsoft earlier. I think we probably have similar viewpoints, which is basically the AI supply chain is very complex. And there is, I think, some value in the simplicity of developer deployer. And then the way that we sort of anticipate managing those expectations of customers is that we would fulfill our obligations on documentation and provide them the sort of evidence that they need to kind of do what they need to comply as a deployer. And I think that my perception is that a lot of this can really be dealt with in contracting, and may potentially be an opportunity to leave it out of legislation. But again, I think we're also open to continuing that discussion and finding the right solution.
Yeah, and my thought was almost modeling the data privacy, the controller processor, where it has to be a contractually defined process for the integrator, developer or developer sub-developer, but still needs work. So, okay, thank you very much.
Good to do that. Thank you.
Thank you, Nicole, for the questions. Senator Maroney and I are generally having these conversations halfway across the country, but appreciate you guys coming and presenting. I haven't figured out the integrator myself yet either. So thanks for the feedback.
My pleasure.
We might have to put you guys in a room to hash it out and let us know why and why not. Thank you. So I see next I have on the agenda Grace Gedye with Consumer Reports. Pulling her up. There's Grace. Good afternoon, Grace.
Good afternoon.
Or early, late afternoon, wherever part of the country you're in. Good to see you. You know, I don't know if you want to introduce yourself and start with your report.
Absolutely. Can you see my shared screen?
Yes, we can.
Fantastic. Well, thank you all so much for having me today. I'm with Consumer Reports. I work in the Consumer Protection Policy Division, so alongside all the fabulous consumer product testing we do and investigative journalism, we also have folks doing nonpartisan policy advocacy on consumer protection issues. I work on AI, and I spend a lot of my time working on state-level AI policy, because it's where some of the most dynamic policy is happening. So briefly where I'm going to go today, I'm going to start with a quick example, part of an example to ground why some of the direct consumer protections in these bills, particularly the pre-use notice, the post-decision explanation, the right to correct, and the right to appeal, I think are so important. Then I'm going to flag that I think some additional details are needed in the consumer disclosures, particularly in the Texas bill. Then I'm going to briefly touch on this issue that I think has already come up a few times today of the substantial factor and how it interlocks with the definition of high-risk AI system and the potential problems I fear it could cause for noncompliance down the road. And then lastly, touch on enforcement and ensuring that enforcers are adequately resourced. So this example, I just want to start with a renter applied for a rental unit. They're someone who worked in government and had to undergo national security clearances. So they'd undergone very scrupulous, detailed background checks. But when they were submitted to an algorithmic screening background check for this apartment, that background check recommended that they be denied because it found that this applicant had a drug conviction and 3 misdemeanors for petty theft. That's because the algorithm had confused it with another person with a similar sounding name who did indeed have those misdemeanors. That was just a straight up mistake that the algorithm made. Luckily, it came to light because of federal credit laws that covered this specific instance. And federal credit laws require that consumers receive explanations after certain kinds of adverse actions. Something that I think is really great about these AI bias and transparency bills that we were asked to analyze today and that we're seeing across the country is that they open this portal for consumers to understand how these decisions that shape their lives are made and, you know, enable them to spot these kinds of errors that would otherwise have a huge impact on the kinds of opportunities they have access to. So these bills make a huge step forward towards kind of opening these black box algorithms that make these consequential decisions. But I think a bit more is needed, especially in terms of the language about what is required in the pre-use notice to consumers, the post-decision explanation for both bills, but particularly the Texas bill. Here, I've got an example of what some revised language could look like for the pre-use notice, and I'm happy to share detailed language with any legislator who's interested. And I know in some cases we already have. I also have some concerns about exemptions that narrow the scope of the bill, hampering transparency. So, for example, one exemption to the definition of high-risk AI is if the tool is doing a narrow procedural task, but the term narrow procedural task is not defined. And I think, you know, some of the common high stakes uses of these AI systems could be argued that they're narrow procedural tasks, right? Is screening a tenant a narrow procedural task, or is screening a resume a narrow procedural task? I don't know. And I think that ambiguity could lead companies to interpret that these rules and these disclosures do not apply to them, which I find concerning. And lastly, I just want to underscore, like, the reason why I'm kind of harping on transparency requirements is for two reasons. One, they will enable consumers to pursue their existing rights under other laws. So, existing civil rights laws, disability protection laws, UDAP laws, and then, for enforcers to get a sense of when they need to use their investigatory powers, they need some breadcrumbs, and these disclosures begin to provide those breadcrumbs. I know Matt Scherer from the Center for Democracy and Technology really delved into this, and he made a lot of points that I would make, so I don't want to get too far into this, but I do have serious concerns that the definitions that we're seeing for substantial factor in both the Texas bill and the Connecticut-Colorado bill that was circulated could create a major non-compliance problem, as we did see in New York City's local law 144. So I do have that concern, and I think a good alternative definition would be the definition passed in California under AB 2855. I know the legislators on this call are just working so hard on these bills, and I would hate to have a similar outcome that we had in New York City, where after all the work that's been put into a bill to craft it and to get through the legislative process, we have this outcome where it's not having much of an impact because companies don't feel that they are covered and are not complying. And then lastly, I want to touch on enforcement because, again, to really see companies change behavior, enforcement needs to be robust. And as legislators are probably keenly aware, their AG offices are working hard, but are stretched very thin by the numerous laws they need to enforce. I think a private right of action is completely appropriate, especially given that these bills deal with the issue of algorithmic discrimination, and in many cases are modifying existing state consumer protection laws that have private rights of action. I was heartened to see the introduction of SB 1169 in New York by Senator Gonzalez, which has a private right of action. And I know the initial draft of the Texas law had a private right of action for subchapter B, the prohibited uses. So I think this is a very appropriate venue for a private right of action. But on top of that, and regardless of whether or not a private right of action is added, it's imperative that the AG offices tasked with enforcing these bills have the resources to hire dedicated staff. And I think one thing we've seen now that a handful of states have their privacy laws in force is that states that have had the resources to dedicate some staff or some additional funding to enforcing privacy laws have seen more enforcement actions. These are difficult cases to bring. They require some expertise, and it's important to adequately resource state AG offices for the task at hand. Lastly, I wanted to kind of wave the red flag about the right to cure in the Texas bill. We have really intense concerns about indefinite and broad rights to cure. They create a very perverse incentive for compliance, right? Like, why would you go to all the effort to come into compliance with the law if you know that on the off chance you are caught by the one actor tasked with enforcing the law, you can then come into compliance and essentially have no ramifications, right? And also, it's pretty unique under the law. There are so many types of laws where you don't get a second bite of the apple. If you run a red light and you hit someone, you can't say, oh, well, officer, I promise I won't do it next time. I'll go to a driver re-education course. It's like, no, someone's been harmed and there needs to be recourse. And so in these cases where, a company's potentially violated the law for discriminating against people, there should not be a right to cure, and certainly not an indefinite right to cure. So thank you so much, and I'd be happy to take questions.
Thank you, Grace. Any questions before we defer to Senator Maroney? That'll be a no. Senator Maroney, you're up.
Actually, thanks, Grace. I think I peppered Matt with enough questions earlier, so I'll give you a pass.
That is very kind of you, Senator. I was watching that and I was thinking, these are toughies. I wasn't expecting these. So.
I'll explain it to you later, but I misread the schedule. I thought I had to kill time. So now I need to get caught up on time because I got us behind. So, all right. Thanks,
Totally
Grace.
fair. All right,
Grace,
thank you.
I have a question I proposed
Senator.
earlier when I got on that maybe you can help, and I didn't get to Matt, but there's a lot of discussions and I haven't figured it out. And Senator Maroney and many of us that worked on this is always like the small businesses are like, some of this is excessively cumbersome, and what is a definition I go, why should a small business get to discriminate versus another one? And as we look at other avenues of looking at how we define a small business in this industry, just wonder if you have any thoughts. As like, as I look at other ways maybe of streamlining some stuff, but not carving out, I really struggle with figuring out how you define a startup or a small tech business. Because you can have one at 10 million with 50 employees, and you can have one making 40 million with 2 employees. And and I don't know if you have any thoughts on that, knowing a little bit of the industry. And I've asked some of the tech people, but interested in this in the civil side, if you had any thoughts on it.
Yeah, I'll share two thoughts. One in terms of like definitional thresholds. I think because the goal is to protect consumers, drawing the threshold around how many consumers are being impacted versus the revenue or the number of employees might be appropriate. Because as you said, sometimes you'll have startups maybe with only 10 employees, but they've sold a product that's now affecting thousands of people. They should probably come into compliance. So I think drawing the threshold around how many consumers are being impacted is going to more accurately track the kind of impact they're having on consumers. I do think that especially with something like algorithmic discrimination, our existing discrimination laws have very low, either no small business exemptions, or in some cases, a small business exemption of 15 employees. I hope I didn't get that right, and I'm sure someone will correct me if I got that wrong. And so I do think, for the top line, either duty of care or prohibiting discrimination, there should not be small business exemptions. But if there are particular provisions that might be particularly onerous for small businesses, perhaps those provisions could be carved out for small businesses. And I don't know if that would be the impact assessment or some other element, but it doesn't seem like it would necessarily need to apply to the entirety of the law.
Yeah, I don't disagree with you. That's why I've okay, I don't know how. A lot of pushback I'm seeing. It's like, oh, you should adhere to the consumer data privacy law, which as one of the first states that I think those numbers were pretty, I think people pulled it out what was reasonable. I think my colleague Maroney tried to lower that in Connecticut, and it was harder. So it's some of those numbers are just throwing it at a dartboard, and then somehow it becomes the norm. And as I think through this, then like you said, I looked at the number of consumers affected, but then I start thinking about, all right, school assessments aren't going to be as high as probably job applications. And that's where I'm now I moved to this threshold of users it makes a decision on, but then I start looking industry by industry, how that varies based on, loans for housing or or applications for jobs versus assessments for kids for education. And just appreciate your thoughts. And if you continue to think as I see you, we'll see you in other spaces. Just I'm trying to dig into that myself. So just wanted to put that out to you.
Absolutely, Senator.
Senator Maroney, you got any follow-ups on that?
No, yeah, I think we need to think of it in two ways. I'm seeing the developers, maybe the sandbox and tools to bring people into compliance, but then with the smaller deployers, that's where I see more. It's a little harder to figure out.
Yeah, we've 3 years and we still haven't been able to figure this out. I keep relaying how hard we'd like to figure it out. It's just not that easy. Any other questions from anybody else in the group? All right. Thanks, Grace, for your presentation.
Thank you both so much. Have a great rest of your evening.
Next up, I have Duke University, Mark Sendak, if I pronounced that correctly.
Hello, yes. You pronounce it great, Senator Rodriguez. So quick note, I did have to run home at the end of the day, so I'm here with 2 dogs. If you hear barking, my apologies on that front. So I'll kick off. Senator Maroney and members of the Multi-State AI Policymaker Working Group. My name is Mark Sendak, and I appreciate the opportunity to participate in this session. I must note that any views expressed today are my own and do not reflect those of my employer or the institutions that participate in a multi-stakeholder collaborative of which I am proud to serve as a leader. So I am the Population Health and Data Science Lead at the Duke Institute for Health Innovation. You'll hear me refer to DHI for short. and I am the co-lead of Health AI Partnership. I studied mathematics and health policy before completing medical training and have been developing and implementing AI technologies in healthcare for a decade. Since DHI's founding in 2013, our team has developed and implemented over 50 AI technologies, including a portfolio of 9 generative AI projects. We were the first in the United States to implement a deep learning model into routine clinical care, and we were the first to implement a model facts transparency label for AI tools, laying the groundwork for federal regulation for algorithmic transparency. We have also incubated 4 companies to commercialize AI products built at Duke, and we help external organizations validate those technologies. Since launching Health AI Partnership in 2022, our National Learning Collaborative has grown to 20 healthcare delivery organizations across the country, ecosystem partners that include the American Medical Association and EPIC, and federal agencies including CMS and ONC. Our healthcare delivery partners provide services in many of the states represented on this call, including organizations like Kaiser, Morehouse, and Ochin. Regulation for AI in healthcare should be sector specific. AI in healthcare is not new and builds on a long history of using statistical models to improve clinical decision making. Clinical research is data-driven, and medicine has long aspired to move evidence into practice, and AI is a critical tool to improve how high-stakes decisions are made on the clinical front lines. The multi-state AI policymaker working group can take concrete action to improve the safe, effective, and equitable use of AI across states. First, this group can streamline efforts to advance transparency of health AI systems. In healthcare, transparency efforts must extend beyond AI system developers, deployers, and distributors to also include affected stakeholders, namely patients and caregivers. Starting on January 1st of 2025, a new federal rule called HTI-1, enacted by the Office of the National Coordinator, requires electronic health record vendors to share 31 source attributes about AI products with AI deployers. Unfortunately, this information only covers a subset of health AI products and only requires transparency between the system developers and deployers. This working group can align transparency requirements at the state level with the 31 source attributes specified in the new federal law. This group can broaden transparency requirements to cover additional categories of health AI products, and this group can ensure that patients and caregivers also have access to AI product information. Second, this group can diffuse state-based AI professional support services programs to support the adoption of best practices that are proposed in the Colorado and Texas state bills. Through Health AI Partnership, we have worked closely with leaders from well-resourced healthcare organizations to define best practices for health equity impact assessments and post-deployment monitoring. These activities do require significant infrastructure and expertise that is lacking in the majority of healthcare organizations in the United States. Last year, in 2024, Health AI Partnership launched the nation's first free technical assistance program to support AI product lifecycle management in federally qualified health centers and community hospitals. We are supporting the implementation of AI scribes, EHR vendor products, as well as an FDA-approved device in community and rural settings. None of the organizations participating in our technical assistance program employ data scientists or have staff who can interpret and act on the results of AI product evaluations. Our pilot program is building capabilities at 5 organizations, while there are 6,200 hospitals and 1,500 health centers in the US. What you will find when you ask healthcare organizations to describe post-implementation monitoring and health equity impact assessments will be mostly blank stares. While awareness to perform these important activities is critical, to move the needle on adoption of these best practices, states must invest in capacity building programs. We need capabilities before demanding compliance. We are excited to share that Health AI Partnership is kicking off a planning grant in California with 2 philanthropic partners to design an AI technical assistance operating model for the California safety net. We will be putting this operational model in front of philanthropic and state leaders over the next 6 months. This working group can spawn similar efforts in states across the country to rapidly scale capabilities for post-implementation monitoring and health equity impact assessments. I look forward to continuing to share learnings from Health AI Partnership and DHI and to continue to support the work conducted by this working group. Thank you again for the opportunity, and I look forward to answering your questions.
Thank you for that. Any questions from anybody in the group? I
Yeah.
appreciate your thoughts. Senator Maroney.
Thank you. Mark, thank you so much for presenting. I think I'm going to reach out to you offline. I have questions about, you mentioned the companies that were spawned out of the DHI. It's one of the things I want to look at is tech transfer, right? We have Yale has their own venture firm, but are other colleges and universities in Connecticut maybe creating a combined resource to assist them with some of the, they're getting their IP commercialized. The other I'll reach out to you separately about is data sharing among hospitals and insurance companies and universities in Connecticut. I think, trying to create some privacy enhancing, some form of a confidential computing cluster. I'd love to get your input on that. But the other thing, so you mentioned the medical transparency, and I didn't know if you had language on that, right, to go beyond the 31 requirements, right, only cover a subset of the health AI products in line state level, the 31 in federal law. If you had recommendations on that you could share, that would be great. We'll send it out to everyone, as well as information on the pilot program that you mentioned. I think we could distribute that to everyone, especially if you had proposed legislation surrounding that.
So a few comments. One of the reasons I include in my comments that we commercialize technologies is because, and I've found this especially in the last few years, healthcare is a complex domain, and one of the hats I wear is as an innovator. So I can speak to the perspective of what it means to build products. A lot of folks who actually do AI and machine learning research may not fully grasp that they are building technologies that are commercially valuable. And I would say healthcare really is one of the domains where you can have commercially valuable products without scraping the entire internet to build a technology. A lot of big tech, you really do need massive compute, massive data sets to build commercial products. Healthcare is a space where many of the organizations in your jurisdictions can really build and may be building products that need to be diffused. So a lot of the innovation actually comes from within delivery organizations, and we try to foster that both within our own organization as well as in other organizations. You asked about specific language for the federal law. So I don't know who this is visible to, but I just dropped in the link here to the HTI-1. This is the Office of the National Coordinator. On page 2 of this kind of fact sheet is where you see the full list of the 31 source attributes. So part of this was inspired by our own work developing labels for our own clinicians. And so ONC now, the Office of the National Coordinator, they require electronic health record vendors to provide information for these 31 source attributes to the AI system deployers. The reason I say that that's limited, one is that there's a lot of other categories of healthcare AI products that don't fall within this rule. So for example, at Duke, if we are building and implementing the products ourselves for our own patients, we aren't covered by this rule. And you may want to scratch your head and say, well, why is that? Wouldn't you want the same attributes? And I'm here to say, yeah, that would make sense. The other limitation is that this federal law only requires transparency between the developer and the deployer. It doesn't require anything for the affected stakeholder, which at least in my comments, I'm saying are patients and caregivers. So even if my doctor sees 31 source attributes about an AI product that my doctor is using and providing me healthcare, I guess I'm posing the question of why don't we go the next step and actually require that the flow of that transparency propagate to patients. So those are kind of where the current federal law is and where I see states as being able to kind of help take us to the next steps. And then your comment about the pilot program, I'm happy to follow up. I can give folks a sense of we're working with 4 FQHCs, 1 community hospital. Folks need a lot of help. I mean, I tried to give some concrete examples of most of these sites don't have data science capabilities. Even if we make tooling, and we're doing a project with Epic on this, public open source tooling to be able to support small organizations to locally validate products themselves and do post-deployment monitoring themselves. What that means is that somebody is posting and updating Python code on GitHub, but you still need somebody who knows how to program in Python to download that code and run the code and interpret the results and then translate the results of that analysis into operational decisions for healthcare delivery. And those are just infrastructure and skills gaps that currently exist.
Great. Thank you very much.
I don't see any other questions. Mark, I appreciate you. I think you're right, and it's in a room. I think a lot of us, we've always known that, yeah, the industry by industry is way more complicated, and I don't think this bill was designed for that. And obviously, these definitions get narrowed down as we go industry by industry because everyone is different, just as we talked about the definition of small businesses. But, I appreciate you being here. If there's no other questions, I think that's all we have. Oh, wait, nope, I have one more person presenting, and that's Carl Williams with Epic. Thank you, Mark, Mr. Sendak. Kara, there you go. Can you hear us, Kara?
Hello. Yes, sorry, my computer is lagging. Can you hear me?
Yes, can hear you. Please introduce and proceed.
Great. Okay. Well, first of all, thank you all for inviting me to speak today, and thank you to all the lawmakers on the call for your hard work on this important issue. My name is Kara Williams, and I'm a law fellow at the Electronic Privacy Information Center, or EPIC, and I focus on state privacy and AI legislation. EPIC is an independent nonprofit that was founded 30 years ago to secure the fundamental right to privacy in the digital age. EPIC is an independent advocacy group. We take no corporate funding so that there is no question that we are advocating on behalf of individuals' rights. EPIC is also nonpartisan. We work with legislators from both sides of the aisle to meaningfully protect consumers and workers. I'd like to start off today by talking about 3 ways that bills that regulate algorithmic discrimination, including both the Connecticut and Colorado models and the Texas bill, can be strengthened to better protect consumers and workers. As nearly everyone today has mentioned, the strength and weakness of these bills really is in the definitions. The definition of substantial or contributing factor needs to be clear and broad so that it can ensure all systems that can impact a consequential decision are covered, and that businesses cannot use a rubber stamp by a human as a way to avoid compliance with these laws. Merely adding a human in the loop is not enough. An automated decision system should be covered by these bills if the output of the tool that is being used during the process of making a consequential decision. Only covering automated decision systems if their output is the sole or controlling or most heavily weighted or some other configuration similar to that factor in a consequential decision would allow companies to avoid complying in many important contexts which consumers and workers should be protected. Epic would agree with the earlier presenters this afternoon who brought up the California AB 2885 definition, that this is a good definition that should be used instead of the current definitions in either the Texas or the Colorado, Connecticut model. And I think other presenters have offered to follow up with that text, but I am also happy to include it in my comments. Epic's second suggestion would be to replace the duty of care framework with a prohibition on selling or using automated decision systems that result in algorithmic discrimination. A duty of care is simply insufficient for addressing algorithmic discrimination. As a society, we do not accept reasonable care as the standard in any other civil rights context. Instead, there is an outright prohibition on discrimination in many contexts that this bill covers, including housing, education, and employment. Discrimination using an automated decision system should not be treated as less harmful than discrimination by any other means. And by this same reasoning, Epic also has concerns about the inclusion of rebuttable presumptions and affirmative defenses that allow developers and deployers to avoid all liability if they have taken certain actions. Setting up a risk management framework or something similar should not be enough for a company to avoid liability for discriminating against a job applicant, a prospective student, or a patient in need of healthcare. Lastly, more robust enforcement mechanisms are necessary for these laws to truly be effective. Including a private right of action, especially given that these bills are non-discrimination laws in nature, is the best way to ensure compliance while preserving your state's resources. Another way to strengthen enforcement of these bills would be to include dedicated funding and support for AG's offices. And Texas is a great example of this. Texas has been the only state whose attorney general has brought an enforcement action under privacy laws so far, and a big reason why is that they have a dedicated privacy division. So in addition to these concerns, I also want to highlight a couple of great additions that I saw in either the Texas bill or New York Senator Gonzalez's New York AI Act. First, both the Texas and the New York bills prohibit certain uses that are especially harmful. Epic was particularly happy to see the prohibition on social scoring systems and would encourage other state lawmakers who are considering this issue to add in a similar provision. Second, and Senator Maroney, you brought this up earlier as well, Epic was also excited to see that the Texas bill included revisions to its comprehensive privacy law to ensure that it remains up to date with emerging technology and that consumers and businesses are clear on how their privacy rights and obligations apply in terms of AI. Lastly, I'd like to quickly address a couple things I've heard today from other presenters. First, many of the presenters warned you today that regulating AI could hurt innovation. But innovation is not inherently good. Responsible innovation that prioritizes protecting individuals and their privacy and civil rights is good and should absolutely be encouraged, but innovation just for innovation's sake should not be. Plowing ahead with high-risk technologies for innovation's sake without putting carefully thought-out guardrails in place will cause more harm than good. Regulating automated decision systems is an urgent need, and Epic encourages state legislators to move forward with their efforts to pass meaningful AI legislation and looks forward to continuing being a partner. Please consider Epic a resource moving forward. We work with many state legislators, including some of you on the call today, and would love to connect with any lawmakers considering regulating either privacy or AI. I appreciated the opportunity to talk with you all today, and I would be happy to try to answer any questions. And thanks for sticking with us until it's 6 p.m. where I am. So thanks for hanging on.
Thanks for bringing us home. The closer.
Yeah.
So, all right, Kara, thank you so much. Let me see if there are any questions. Okay. I don't see any questions. If you could send your written feedback, I would appreciate that. I do have and again, I'm going to think out loud. And so, forgive me because it's not completely formed thought. the duty of care versus the strict prohibition, right? So one of the things we know about the technology, a few things, right? That there is bias is almost inherent, right, in the systems, and that's why we're testing it, trying to fix it. But also we know there's drift, and we know that models change, which is why we have ongoing, we want to require ongoing testing. So, like, agreed, right? We don't allow discrimination anywhere else, and that's also why I don't know. It's hard with figuring out a small business exemption. Why, if you're small, should you be able to discriminate, right? I think it's more what relief can we provide on some of the obligations versus exempting. But I guess my concern is if we do a strict prohibition, does that prohibit every AI system from making a decision, since we can't be certain, right? That even if it's not discriminatory now, we don't know, right? And that's why, again, we want to the transparency, there are so many pieces of this that are important, right? To make sure that we're achieving our goal, right? Our goal is zero discrimination, obviously, but again,
Right.
just recognizing that bias is almost inherent in the technology.
Right. So a couple thoughts on that. It definitely does not prevent any AI from making any decision because of these definitions that I know you all have spent hours poring over. We're only talking about the most harmful uses of AI, the high risk decisions in the context of someone's, livelihood, their home, their education, things that we hold high in our society and that are like the highest risk. So you've already narrowed it substantially. And these testing and impact assessment requirements that these bills require and incentivize also do some work toward that. But the bottom line is, if I am a job applicant and the decision that a company chooses to use discriminates against me because of some protected class, I've been harmed. And as a consumer, a job applicant, I'm not sure that I care if my harm happened because the model drifted and the business didn't catch it. So there are just some harms in society that you take on as a business owner, not to put my lawyer hat on too much, but that's why we have strict liability for some things. We just don't accept the harm at all. And I think discrimination based on a tool that a company is using that the company doesn't understand enough to avoid discrimination by using is one of those harms.
Thanks. Thank you. All right. Let me see if there are any other questions. No, I don't see any other questions. So if you could please send along your written recommendations, we'll make sure that's distributed to the whole group. And I guess with that, we'll just wrap it up. I wanted to thank all of our presenters. We had a number of presenters throughout the day presenting to us, to thank all of the legislators who attended, and of course to thank the Future of Privacy Forum for serving in their role as a convener in convening this meeting and helping us with the technical support of giving us the access to their YouTube channel and also hosting this Zoom. So thank you, everyone. And if you have any other feedback, please feel free to submit written feedback. I know for the Connecticut bill, we did send out information that Future of Privacy Forum is also going to be hosting a public drive that you can access, and I will be updating that with drafts of the Connecticut bill and ask for people to send back red lines as we continue to work on that throughout the legislative process. And we know that I think I didn't know where it was said before, but now I was at another presentation where someone said that it's an African proverb that alone you go fast, together you can go far. And I look forward to working together with all of you to help incentivize responsible AI innovation across the state.